Thank you, Madam Clerk. Good morning, everyone. This is the July session of the Tennessee Court of Criminal Appeals here in Jackson. My name is Robert Wiedemeyer. It's my privilege to serve with two outstanding colleagues today. Both are from Memphis. To my right, Judge Camille R. McMullen, who is also the presiding judge for our Court of Criminal Appeals. To my left, Judge John W. Campbell, Sr., an excellent colleague from Memphis, former trial judge there as well. Most of you folks have probably been here before, the attorneys especially, and you know you have 20 minutes per side to argue. If you're the appellant and you wish to reserve some rebuttal time, part of your 20 minutes, please announce that at the beginning. The clerk will keep up with it, and we'll let you know how you're doing on that. We have read your briefs on these cases, and of course we will carefully be studying and looking at the records before we issue opinions. We may or may not have gotten into some of these records, but you can be assured we have read the briefs and tailor your arguments accordingly, if you will. You're not required to use all of your 20 minutes. That's another point that sometimes is forgotten by even the best of attorneys who come up here. I think, are there any preliminary matters, Madam Clerk?
No, Your Honor.
All right, I think that's all the introductions I need, so if you'll call the first case, we'll get started.
State of Tennessee versus Joshua Lynn Damesworth.
All right, good morning. Mr. Ridley?
Good morning, Your Honor. Yes, Todd Ridley on behalf of Joshua Damesworth. If I could have 3 minutes for rebuttal.
All right,
minutes
3 minutes for rebuttal. Go right ahead.
Good morning, Your Honors. This is a case involving a revocation of probation where Mr. Damesworth has been ordered to serve 5 years, his total sentence from his guilty plea from several years ago, as a result of his failure to pay approximately $160,000 in restitution. The trial court ordered him to, revoked his probation and ordered him to serve based on that failure. The reason it should be reversed is because the trial court failed to make any findings or failed to make adequate findings supported by the record, suggesting that Mr. Damesworth's failure to pay $160,000 was willful. Rather, what the record shows is that Mr. Damesworth paid what he could. He paid $100 a month per his probation officer's instructions, and even the state—
You said per his probation officer's instructions. What does that mean?
Okay, so the original judgment did not have a payment schedule. It just had $160,000 of total restitution. What the probation officer said at the hearing was that he paid $100 a month, and she understood that he could not pay any more. She did not officially say on the record that she had set $100 as his required payments, and I'm not sure she could have even.
So if that was the case, he was never going to fulfill his restitution requirement in this case?
No, if he had been paying $100 a month, he would never have been able to.
So he was going to be violated no matter what?
I'm not sure I'm following.
He knew he was going to never fulfill the order of restitution, and he never went in to modify it?
Oh, going back to the original guilty plea,
Right.
when there was an agreement to the $160,000.
He agreed to this whopping almost $170,000 order of restitution.
Right. When he pled guilty, he did agree that he would make those payments. Okay, so that being said, there still has to be a finding of willful failure to pay, and coupled with that, a finding that he had the ability to pay. So even if he agreed when this was originally put into place, I think in 2018 or 2017, that $160,000 was an appropriate amount of restitution, his failure to make all of that payment by the end of the 5 years does not make it a willful failure to pay restitution. It just means there was a total obligation set, and to be honest, if I had to guess.
And a finding by that judge was different than this judge, that he had the ability to pay that.
Okay, so there was never a finding that he had the ability to pay when the guilty
Well,
plea
not a
was entered.
finding, but because it was ordered and imposed and agreed to, implicitly, we believe that he could pay it.
And maybe they could. Maybe they believed that in 2018 when he entered the guilty plea. But the test for is the failure to pay willful, that involves the time of the violation, not the time the sentence was put into effect.
The
So
reason I'm asking these questions is because it seems like this particular trial judge was particularly perturbed with the defendant in this case, and his manipulation of the court.
Okay, so the judge certainly did seem perturbed. The underlying rationale for that perturbance, I do not know. What I would say, though...
Perturbance? Did you say perturbance?
I did.
Yeah, good, excellent.
I have no idea
I like
if that's
to
a
add
word.
at least one
I
word
doubt
to
it.
my vocabulary every day.
I highly doubt that's a word. But nevertheless, so the judge did, certainly in subtext, it seemed like he was upset about something regarding Mr. Damesworth. But I don't think there was ever any indication that Mr. Damesworth was trying to pull anything over on the court. And the reason I say that is because his probation officer says he's been an excellent probationer. He's paid what he could. I looked, and he lives within his means. He lives in a modest home. Here's how much money he makes. I don't see any reason why he'd be able to pay more. And it's not only the probation officer who's saying that. The state is saying that at the hearing. So at the 2 weeks prior to the revocation hearing, the state said, we don't want to go forward. We want to dismiss this. We don't see any basis to do this. At the hearing itself, they said, well, you wanted us to put on proof, Judge, so here's the probation officer, but we don't think he has the ability to pay, and we don't see any reason why he should be violated.
Did they say we don't think he has the ability to pay?
Yes, they affirmatively said that, and they said that at the Rule 35 hearing, maybe a month or so after the violation hearing. What they said was, we don't have the proof to show that he is willfully failing to pay this. And some of this didn't make it into the record, but I do think it's helpful for context. What happened here is that Mr. Damesworth's sentence was about to expire. And so the probation officer and the DA say, well, he's been making these payments, but this is a big restitution obligation left. We want to make sure this can convert to a civil judgment to help the victim. No one has any problem with that. And to this day, we have no problem with it converting to a civil judgment. So they file the violation in the hopes of making the conversion possible. Now, they didn't need to do that. There's nothing in the statute that requires them to do that to convert a restitution award into a civil judgment. So I think that was just legally unnecessary.
Did the
But
trial
that,
court here make any comment about that civil judgment and whether or not the victim would ever be able to obtain any money from that?
normally in these cases, there is a comment like that, but no, I don't believe there was in this case. And you never know. Those civil judgments are good for 10 years from the date they're entered, and you can extend them for more or less indefinitely. And maybe this would be something that she'd be able to collect on. If at a minimum, she'd likely be able to continue to get $100 a month through a garnishment or something else, or just because Mr. Damesworth is still willing to pay that amount towards a civil judgment, restitution, whatever you want to call it. He is willing to make those payments. But his willingness to make those payments now says nothing about his ability to make a full $160,000 payment at the end of his probation. But yeah, what I was getting at was that the plan by the DA and the probation officer was, we don't want to send this man to prison. We just want this to convert to a civil judgment. I don't think the way they did that was necessarily correct, but I understand their impulse, and I don't want to discourage DAs from doing that. But what I do want to discourage is, or I want this court to discourage, is from a trial judge just taking over the proceeding entirely on his own and basically taking the place of the DA and saying, I'm going to try this case for you. So the DA stands up.
Is that what happened here, or did the trial judge just say, I'm not going to accept the agreement in this case?
I think the trial judge did much more than just say, I'm not accepting the agreement. The trial judge said, I'm not accepting the agreement. State put on your proof. The state put on very little. basically just from the probation officer, and the probation officer saying he can't make these payments.
Well, didn't the probation officer really basically say that she didn't really check anything? Because she didn't check behind anything because he didn't have any, he didn't have a W-2, I don't think. He didn't have any tax returns. And sometimes his dad paid him in cash and sometimes he didn't. So it was kind of nebulous about really what money he was coming in and the terms of his employment.
Okay, so that kind of goes into the who's trying this case question. So when the probation officer is testifying, none of that information was elicited. The probation officer simply said, he doesn't have the ability to pay. All of that information about W-2s and how his father was paying him or not paying him, that came from the trial judge asking.
So is the trial judge not able to ask follow-up questions if there's a hole, like if they're, to look and see what the basis of her opinion is?
Sure, the trial judge is certainly allowed to ask questions, and in the context of probation revocations, which are much more informal, they have more leeway than they would in a jury trial. But that does not change the fact that when those facts were elicited, it's the trial judge asking those questions after the DA says, I don't have any more questions, I don't have any more proof to elicit because I don't think we have any proof on this. And then what happens is the trial judge says, well, I have a bunch of questions, not only for the probation officer, but I have a bunch of questions for Mr. Damesworth himself, and I'm going to take it upon myself to conduct that examination entirely without.
You're not raising the trial court's questioning of the defendant as an issue in this case?
No, not as an independent issue. There is case law from this court that a trial judge is permitted to do that, and the trial judge is not required to accept the state's dismissal. So accepting that as just a foundation that we have to deal with, that does not change the fundamental nature of this hearing where the trial judge is acting as the advocate for the state.
Let me stop you right there for just a second. What were the mechanics of how this defendant was required to testify? Because I think in one of the briefs it says the lawyer for the defendant made some kind of objection. The state has the burden of proof. I probably should ask the general this, but the state has the burden of proving the violation. The defendant has an attorney there to represent him. And so when the state finishes the way I understood this, the state is through presenting their proof. And the next thing you know, this defendant has been sworn in and being required to testify. He's hanging over his head is the possibility which occurred of him going to the penitentiary. I know the state has a case in there that says something to the effect a probationer can be interviewed at the probation hearing, and I'm going to give him a chance to follow up on that. But it just sort of struck me that, I know it's not exactly the same as a trial, but, and it's, the rules are a little more flexible, I guess you could say.
Certainly.
But how did that happen? Did the judge just say, well, state, you may be through with your proof, but I want to hear a lot more about this. Mr. Defendant, get up here, get on the witness stand, swear him in, clerk, and then start examining him. Is that how it happened?
That's almost exactly what happened.
Okay.
I think that.
I used to be a trial judge.
And I think that's pretty much exactly how it went. The state said, we're done. And the judge said, well, I want to hear from Mr. Damesworth. And there was an objection by the defense to him being called. The judge pushed back on that a little bit. And ultimately, we permitted the judge to ask questions.
Okay.
So there was an objection, but ultimately what the judge said was, well, I can ask questions. He doesn't have to answer them if he doesn't want to, but I'm going to ask. Now, implicit in that is the person who's saying you don't have to answer my questions is also the person who's deciding the consequence.
Right.
So whether he had a choice to answer those is debatable, I would say.
Right.
But the underlying point is that ultimately, this became the trial judge prosecuting this violation, where everybody who represented the state until this appeal has said, we have no interest in incarcerating Mr. Damesworth. The only interest we have is helping this victim get more restitution payments. And the only thing that will certainly not help the victim get restitution payments is Mr. Damesworth being incarcerated. So if he's making $100 a month payments when he's out working for his dad, he's certainly not making any payments when he's in the Henry County Jail. And the biggest obstacle to him making a living to make payments towards restitution, whether it's restitution or a civil judgment, is employment. He is limited in what kind of contracting jobs he can take because of his conviction and while he's on probation, and he's certainly limited if he's in the local jail. So if the concern is helping this victim get money to compensate for the loss caused by the original offense, there is nothing that 5 years of incarceration is going to do to accomplish that. And the important part of that is the Tennessee cases on this say the consequence is very important. It says, okay, so we have a willful finding of inability or a willful finding of failure to pay. But what we also need to have is some indication that this punishment, incarceration, is going to accomplish the goals of the state and accomplish the goals of the victim. This does neither of those things. The state, as represented by the DA, was forthright in saying incarceration is not going to help anybody. And the victim, who was not there to testify, is certainly not going to be helped by not getting $100 a month. Whether that's the full $160,000, no, it's not that, but $100 a month.
What the court was going at is undermining the court's orders. I think that was one of the things that was in the very extensive order revoking the defendant's probation in this case. This particular trial judge was very concerned with manipulation of the court and abiding by the court orders. So is that not a justification?
I don't believe so, because I didn't see any evidence of manipulation on the part of Mr. Damesworth. I think, candidly, I think there was a mistake when he pled guilty. That I don't know if he was misadvised or I don't know how those plea negotiations went. But when he agreed to pay $160,000, that frankly was just not going to happen when he can't work at the way he worked prior to
We
this.
can't consider that, Mr. Ridley.
Do what?
We cannot consider that. There was never an appeal of the restitution.
No,
There
no.
were never any modifications or motions to modify. None of that is before us. We can't, I mean, I understand what you're saying, even if we're sympathetic to that. We can't consider any of that. So, you know, I guess I'm just wondering why you're going to, there was a fundamental mistake in pleading guilty to this amount of restitution.
I agree. For purposes of this appeal, it does not matter. I'm mostly adding that for context because it is odd when you see this huge restitution award and then what you see is immediately after it, the probation officer saying, well, $100 a month will work.
Yeah.
I'm looking.
Well, this was a construction fraud case, right? And the defendant works for his father's construction company.
Okay, so that's where he works at the time of this revocation hearing. The underlying basis of the original charge, I don't fully know.
I believe it's in the court's order from the prior probation revocation, I guess, findings. I don't know what it was, but he swindled an elderly woman the amount of money to build a home that she never got, and she was never paid the money that she gave him. Is that?
That is correct. So that much is in the order. What I mean is I don't know all the ins and outs. It's not like there was a jury trial.
And he got an offer, he got a settlement much less, I mean, he pled to a lesser included offense.
It would appear so.
Yeah. And so I guess the trade-off is you pay your restitution, but you'll plead to a C instead of a B felony.
But again, this is like not being able to answer the original question about the underlying basis of, I don't know what those plea negotiations were or what the state gave up to get that or what Mr. Damesworth gave up. The only thing I know is here's what the judgment was for and here's what the restitution order said. And it requires him to pay $160,000 in that period. And if that's all there were, then we lose. But the Tennessee Supreme Court and the U.S. Supreme Court have been clear. If you're going to put somebody in prison for failure to make restitution payments, there needs to be proof that the failure to pay was willful and that he had the ability to pay. In this case, there was no proof of either of those things because the party that was in charge of putting on proof of those things said, we can't prove it.
And we can't, from your perspective, we cannot rely on this trial judge's findings that the defendant lied when he asked him specific questions about his employment, or his ability to get a second job, and those things, all of those things that are outlined in the order that was filed by the trial court in this case.
I do not think that a negative credibility finding can make up for the lack of affirmative proof from the state, because it would be like the state shows up and says, we're going to prove X, Y, and Z, and that's their burden. And then they get up and say, well, we don't want to. And then the defendant gets up and says, I didn't do any of that. And the judge says, well, I don't believe you, so I rule for the state. And it becomes a situation where at a certain level, then the judge is acting as the state's advocate because the state decided we don't have any interest in pursuing this.
Well taken.
So that fundamentally is the problem.
I see that you're out of time,
Yes.
but I have one question,
Sure.
if I may.
Certainly.
Are you, usually I see in the appellate division reply briefs, responses to the states, all of the states' attacks to the issues raised. You did not respond to the graduated sanctions or the technical, non-technical aspect of your initial principal brief. Are you conceding that the state is accurate in their position, in their brief?
I'm not conceding that the state is accurate in full. What I will concede is that the trial judge still has a fair amount of discretion, despite the graduated sanctions statute, in what remedy they choose to impose. My point in raising it is simply that the statute specifies a baseline of what the punishment for this sort of offense should be. And if a trial judge is going to exceed that by orders of magnitude, if the statute says 30 days, 5 years is quite a bit more than that. At a minimum, the trial judge should say why. And the trial judge did not do that here. So I rely on the statute not to say he was required to only do 30 days of punishment. He had more flexibility than that. But if he's going to go that far beyond the 30 days that the statute calls for, there needs to be something more to explain why 5 years of incarceration is going to accomplish something.
Thank you.
If I can, I'll just reserve the remainder of my time. Thank you.
Certainly, thank you.
One second, General. There was beeping, was that correlating to the end of his time? Okay. That's what I thought it was. It was not me, I wasn't trying to rush you, but,
I don't know. I didn't, I heard a beep, yes, but
I thought it was coming from like behind that door over there, but.
yeah,
Maybe
there's
the
something
mic.
going on with the mics or something, or
Yeah.
the speaker system over here. It stopped now, but I. Okay, I think they're letting me know that it was a medical device that was going off over here.
Oh,
Thank
okay,
you very
okay.
much, thank you,
Yeah,
thank you.
thanks a lot.
No, it's not a problem. I just wanted to make sure there wasn't anything going on with the mics here.
All right, General Douglas, come on up.
Good morning, Your Honors.
Good morning.
May it please the court, Davey Douglas, on behalf of the state. This court should affirm the judgment of the trial court here because the trial court did not abuse its discretion by revoking the defendant's probation after he willfully failed to pay restitution. And I'd like to start with a point that Judge McMullen, you brought up that was discussed. There is absolutely no evidence here that there was a mistake when the defendant pled guilty, and that's not something for this court to consider. We actually have the opposite, though, and Judge Campbell, you sort of alluded to this. The defendant, part of his plea agreement, he was able to plead guilty to a lesser included offense. He was able to receive a shorter sentence that was He received judicial diversion, and then he also agreed to pay $167,000 in restitution after he initially stole $197,000 from the victim. So the defendant here was really receiving a huge benefit, and part of that benefit was he was going to continue to pay restitution. And then, as the trial court found here, by only paying $100 a month, not trying to get a second job, not having any proof of income, the defendant was essentially continuing the fraud that led to his initial conviction. And the court here was absolutely within its discretion to ask the defendant to testify. And Judge Wiedemeyer, I know you were asking about sort of that process, and I would agree with Mr. Ridley about sort of how the court went about it. The state called the probation officer, and then the trial court expressed an interest in hearing from the defendant. But the trial court also made it very clear to the defendant that the defendant did not have to answer any of the court's questions. And that procedure was consistent with the same procedure this court upheld in State versus Barker. And right here, once the defendant did testify, the trial court was absolutely entitled to assess the credibility of his answers and to make findings and determinations that there was a willful failure to pay restitution here.
What was that evidence?
Starting with first the fact that he owed and had agreed to pay $167,000.
So that is evidence of willfulness from the state's position?
That's part of the evidence, Your Honor, yes, that there was this agreed to amount, and then after 7 years, we only have.
So whenever we have a restitution order, we can look at the fact that there was an initial agreement as evidence of willfulness? That the agreement in and of itself is what I'm understanding you to say, is evidence of willfulness?
It can be, Your Honor, yes, and particularly here where there's an agreement that this is part of a plea agreement, and this isn't sort of a separate step of the trial court imposing restitution on its own. This is a condition of the sentence. It's of the guilty plea, and so that's a starting point.
But almost every case we look at with restitution are guilty pleas, and it's like, this is the restitution, and they put it in the judgment and everything else. Almost all of them are guilty pleas, and so are you saying that all of these cases, we basically can look at the fact that they agreed to it as going to willfulness?
It can be something that goes to willfulness, Your Honor. Not, though, that there's just a simple baseline of if there's an agreement and that amount isn't paid, it's automatically willful. That's not what the state is saying here, but it's just a point to take into consideration, like the trial court did here. And then other examples of the willful failure not to pay were the defendant's testimony that despite having skills and training in construction and fiber optics, he never tried to obtain a second job to pay off this amount. He worked for his father for 7 years and only made minimum wage. And what was significant too is the defendant admitted he never received a raise during the 7 years that he worked for his father. The only time he got a raise was right around the time that his probation was set to expire.
Is there any, isn't it equally plausible that the defendant couldn't get a job in his area of, or a line of work, because that is what he is convicted of and on probation for?
Not necessarily, Your Honor. I think what the defendant testified to was that he couldn't get a job as a certified electrician due to his probation, but he was asked multiple times, did you attempt to obtain a second job or a different higher paying job? And he never said yes. He never said that he did that. And when the trial court asked him, was this, and the trial court sort of tried to press the issue, and the defendant, in explaining why he never obtained a second job, didn't really provide an explanation other than, this was the job that let me care for my wife.
So all of the evidence that the state is relying upon for willfulness is coming from the testimony of the defendant?
A lot of it is, Your Honor, yes.
What is not?
The fact that we had an agreement to pay $167,000 in restitution, and that there was only and there was still an outstanding debt of $159,000. And one other point, though, about the testimony I want to clear up a little bit. The defendant's probation officer never expressly testified that the defendant did not have the ability to pay more than $100 per month. What she actually testified to was that she couldn't make a call on that issue. And she then candidly admitted that she had never looked at the defendant's bank records, his W-2s, his tax forms. And that was another thing the trial court relied on to find here that the non-payment was willful. The defendant simply had no record of the amount of money that he was paid while working for a family company. And it was within the court's discretion to hear the defendant's answers, be able to read his body language, hear his tone of voice, and make a credibility determination. That's what this court actually upheld in State versus Ray, where the defendant in Ray made some payments for restitution, but there was still an outstanding amount. And the court ultimately trial court revoked probation and found that the non-payment was willful. This court affirmed that decision on appeal, and it deferred to the trial court's credibility findings. It affirmed the principle that the court didn't believe Ray's explanation for why she didn't make the payments, and that's what we have here. We have a trial court who reasonably made credibility determinations and reasonably concluded that the defendant here was not making sufficient bona fide efforts to pay restitution. And an appropriate consequence for that willful failure to not pay was to revoke the defendant's probation in full and order him to serve his sentence. And then in terms of the consequence that the court imposed, Judge McMullen, just to go to your last question, the trial court here was absolutely entitled to order the defendant to serve his sentence in its entirety, because what this court has said in State versus Butler and what this court has said what the Supreme Court has said is that the law governing a probation revocation consequence is the law that was in effect at the time the offense was committed. And the law at the time the offense was committed here allowed for the court to revoke probation. And unless there are any further questions, we would ask this court to affirm the judgment of the trial court. Thank you.
Thank you, General Douglas. We'll give you your 3 minutes for sure, since we ask you so many questions.
I'll try to make it really quick. So the state has started off by saying that the problem that happened in this case was that Mr. Damesworth had no record of his finances at the revocation hearing. That misunderstands entirely the burden of proof at a revocation hearing. It is not Mr. Damesworth's responsibility to come into court and say, here's all of the evidence that they could have put on or should have put on. It is their job. It is the state's job to put on proof of willfulness and put on proof of his ability to pay. And if the probation officer wanted to collect records related to those sorts of things, she certainly had the ability to do that, but for whatever reason chose not to. And she decided to testify, or she testified truthfully, that she had no reason to think he could pay more than $100 a month. That's the only proof we have from the state on this. So did she come out and say, based off his W-2s and based off this and this and that, he didn't have the ability to pay? No, she didn't say that. But she, as the representative of the party with the burden of proof, just said, I didn't see any reason to think that he could make these payments. And that, in and of itself, is proof that the state couldn't meet its burden, because it had pretty much explicitly said, we know we can't meet that burden, and we're not even going to try. So the state's current argument that Mr. Damesworth was somehow obligated to bring in proof of his ability to pay just fundamentally misunderstands the burdens that are present at a revocation hearing. And for that reason, the state's argument should be rejected. Get into this a little bit because it was mostly a reply brief point just to respond to the state's arguments that at a very real level, the state has waived this argument that revocation was appropriate, because in the trial court, the state never made the claims it is now making on appeal. And it is—
Mr. Ridley, you know, because you sat on that side before, that the state has the ability to change its position from the trial court to appeal, and they do it all the time.
They certainly do it all the time. I'm not sure I would agree that it's always.
It frustrates us.
I'm not sure it's always appropriate, but they do it all the time. And I certainly agree that it's appropriate when it is a jurisdictional question. But here, the problem was exacerbated by the state's failure to do anything below. Because what we have is, we're showing up to court and our opposing counsel is saying, we don't have anything to put on. And that puts us in an awkward position because what are we supposed to do? The party that's supposedly our opponent is saying, well, we don't think he belongs in jail. We don't think it should be revoked. We just want to make sure this lady gets her civil judgment. And we don't have any problem with that. So that puts us in a very awkward position. And it's a problem that I think is exacerbated by the state's habit of changing positions like this. Because when the DA takes one position on behalf of the state, to some degree, citizens and criminal defendants should be entitled to take the state's word for it. And this kind of switch up on appeal is frustrating. And I think in a case like this, where it's not a jurisdictional question, it really just highlights the failure of the state below to pursue this with any kind of interest in incarceration. And so for that reason, we'd ask this court to reverse and order Mr. Damesworth's probation concluded. And I did include, just because we do continue to think this, that if the court believes that a civil judgment is appropriate, as the state did below and as we did below, whatever we need to do mechanically to make that happen, we're happy to do it. We just want the revocation to be reversed and his probation terminated.
Let me ask you this. What alternative sentence do you recommend?
Oh, in this case, what I would recommend is...
Or do you just recommend remand to trial court?
I think a remand might not be useful in this case, given how much time has passed and like where he is. So he has been released on parole, so he's still...
He is released.
But just on parole. So he's been paroled from the 5-year sentence. So he's not in custody right now, but this is still kind of out there. So we're kind of, to some degree, open to suggestions. But what we would say is we're willing to continue making payments. We're willing for this to be a civil judgment. But at this point, the probationary aspect of this sentence is no longer accomplishing anything.
Thank you,
And
counsel.
if there are any further questions, again, we just ask the court to reverse. Thank you.
All right, thank you. Excellent briefs and arguments by both sides. We appreciate it. Call the next case, please.
State of Tennessee versus Dewey Huggins.